But I guess it's a good segue, Robert, unless we've missed anything, to Steve Bannon, where if they don't get you on the substance, they will get you on the procedure. And Bannon got his indictment for the We Build the Wall indictment. Kolfage didn't. And I said, if Bannon, I like to think if I were in Bannon's shoes, I might say, I decline your indictment and I will stand with my brethren. I'd like to think I would do that, but I don't know what I would do in that position. But a lot of good it did to him, because in the wake of Jan 6, Bannon gets a congressional subpoena. The Congress has created their own raison d'etre, their own authority to investigate anything and everything related to the events. I don't want to use the words, Robert, but it rhymes with schmerrists of January 6th. They've designated this as 9/11 2.0, and they've given themselves all the powers in the world to investigate everything and anything. They issue subpoenas to Bannon, who says, I'm not complying with them. I believe I have privilege, executive privilege. If I'm wrong, prove me wrong. And Robert, you'll explain to me why they don't go adjudicate that question first, but then they indict him by a grand jury. And there was a recent court order in that case. Before we get there, why is there not an obligation to adjudicate on the purported defense of executive privilege before moving on a contempt on the basis of executive privilege?
It's very difficult to contest congressional subpoenas in court in advance of a contempt proceeding as a private citizen. So that's the hard part. It's I believe Meadows is now contesting it. Trump, of course, did, and we'll get to what the D.C. Circuit did with that. But it's generally considered difficult to contest it. I would have advised trying it rather than go the contempt route. But it's not uncommon for the lawyers to advise to let them go the contempt route instead and challenge it in that way.
Okay, so he just simply refuses to comply, leads necessarily to an overly zealous, highly politicized, highly weaponized DOJ, Attorney General Merrick Garland. They go and get him indicted by a grand jury on contempt of Congress. And now apparently, Robert, you're going to have to explain to me how it even happened and came up. The United States of America, the Department of Justice, petitioned the court basically to have everything be, if it's not under seal, it's pretty damn close. They don't want anything being made public in the context of those proceedings. What's the word? Protective orders. I don't know what. Basically, Bannon cannot publicly discuss or disclose any of the supporting documents the government supplied, filed, submitted to the grand jury. And the confidential information is going to be next level protection, but even the ordinary documentation in that file is now subject to a protective order. How does it happen? What's the documentation conceivably containing that it would require a protective order in the first place?
So if Julian Assange is the man in iron chains, Steve Bannon is now the man in the iron mask. Basically, he is being prohibited from disclosing any of the documents that are produced to him in discovery in the criminal proceedings to anybody. There has to be permission granted to file it in court for it to ever become part of the public record. And this is absurd. It is increasingly commonplace with prosecutors going to judges saying, we want any of the discovery on some pretext hidden from public disclosure. There were once grand jury records, something else, but it's a completely misapplied doctrine, because criminal discovery should not be subject to a protective order that, unless it entails private information of the defendant that the defendant wants subject to a protective order, unless it becomes pertinent to the trial. But otherwise, these kind of broad protective orders where they seal and hide and order a party, gag a party. I mean, that's what this really is. This is a gag order on discovery. You're not allowed to disclose to the world any information the government gives you unless it's filed in court itself. And so that is extraordinarily broad, no limits, no requirement that it meet any particular standard. The sensitive information has a heightened provision of protection, but all of it is limited under the protective order. This is the same Federalist Society Trump appointee who also ruled across the board in favor of Dominion in the defamation claims. It's another failure of Trump, and another one of these appointees that is unreliable on the bench in terms of liberty interest. Not a surprise, because over half of his appointees were Federalist Society members whose oaths are to something else other than the Constitution, in my view. And they've proven it repeatedly while being on the bench. and in just the brief time they've been on the bench. So this is just absolute deference to the executive branch, misuse and abuse of judicial power to silence a defendant from arguing in the court of public opinion or exposing government malfeasance and misconduct in the court of public opinion. That's all that it really is.
So I had so many things to say, one of which was the idea of preventing the eyes of the public from accessing this evidence. So if it's submitted, Robert, in court proceedings, then it becomes public, or is it not still suppressed in the context of court proceedings?
It depends. The court can make a second ruling on that at that time, whether or not to seal it or disclose it. Yeah, so at this point, it's going to be unless he's real creative and aggressive in filing things in court, all this information will stay secret until there's a trial. And how he can get a fair trial in the District of Columbia is a joke to me, as we'll get to with what the D.C. Circuit said about Trump. It's not possible to get an impartial jury or impartial judge, for the most part, in the District of Columbia.
Well, before we get there, Robert, you're a steel man this for me. I can't even conceive of what could be in that indictment, charging documents, the information submitted to the grand jury. I can't conceive logically what could have been sensitive enough to even require a protective order in the first place. Hypothetically, steel man it for me. What could be in the documents submitted to the grand jury for Bannon's indictment that could be necessary remotely for a protective order?
I mean, historically, this stuff is stuff they got through. They claim grand jury secrecy, and anything the grand jury got should be kept secret until it goes to trial. That's not what grand jury secrecy is about. Grand jury secrecy is supposed to be until there is an indictment. The information that the grand jury has, they have to keep secret, not people who testify before it, as the government routinely tries to lie people into believing. But even try to intimidate James O'Keefe and Project Veritas on those grounds. Completely bogus the way they went about it. If any private citizen who appears before the grand jury is not subject to grand jury secrecy, period. End of story. Only the grand jurors and the government and the investigators are that are part of the government's case. So that's usually their pretext. This court order established no independent basis whatsoever for why for this broad protective order. None. Didn't say here's why, here's the kind of information. Said no, if it's criminal discovery, it has to be hidden from the world. That was it. That was all the judge said. It was not well reasoned or well argued in the opinion.
It was barely reasoned at all. The only thing I was asking myself, and I said it in my vlog, is it was granted in part. What part of it was not granted? Because the judge, he opened the caveat. Documents that are already public or already in Bannon's possession are not covered by the order. If that was the concession, well, big freaking deal. Whoop-de-doo.
That was already the law. You can't order a protective. You can't apply a protective order to things that aren't part of the protective order. No, duh.
Why? I mean, that's like, why is that even in the judgment? Okay, that which is in public domain can't be protected. Thank you, Dr. Einstein judge. But I mean, what part of the order was not granted? Where was any? The order basically said, if it's not I forget what the word was for the second part of it, but protected or classified information, it wasn't classified.
It was if they put the word sensitive on it, then it had a higher threshold before it could even be put into court. I mean, the only thing that should have been protected, or there was even an argument for protecting, was what was labeled sensitive, and even some of that was too broad. Again, we have public trials for a reason, and you have a right to defend yourself in the court of public opinion, as the U.S. Supreme Court has said in prior cases, Gentile versus State of Nevada, and yet they're basically denying Bannon that right. They're prohibiting him from exposing government misconduct related to his case.
It's funny, now I'm putting pieces of puzzles together in my head. They tried to do this in the Colfage-Bannon indictment. They tried to get a gag order enjoining Colfage from publicly discussing the trial while he was being indicted on alleged fraud for the We Build the Wall. It's un-effing believable, because the second you extricate from the equation the aggregate knowledge of the internet, public opinion, people who can help crowdsource knowledge to Bannon, you then put one party at an absolute disadvantage, because the prosecuting party has endless resources, endless funds, endless assets to do what they want to do for prosecution, and the defendant can't even make copies of the documents. And if it's sensitive information, Robert, he can't even take notes unless his counsel ensures that the notes being taken are compliant with this court order. And I do want to highlight, it was a Trump appointee for the judge. And that's not to say the judgment has to be either better or worse. It's just to say, I did my entire assessment. I didn't know who the judge was. I said, this order, in my mind, reeks of garbage. Then I say it's a Trump appointee. It's like, holy crap, maybe there's a reason why this is a good order. And I was like, no, this is all bull crap. And I don't care that the judge was appointed by Trump. The judge made the wrong decision, or at the very least, really stretched the bounds of the believable. But they have to live with this court order now pending the entire indictment, or is there anything remotely appealable in this decision?
You can appeal, but you're appealing to the D.C. Circuit. So unless you get a miracle and you get the U.S. Supreme Court to take it, which would be an extreme long shot, you're stuck. And the D.C. Circuit made clear this week in Trump's objections to the January 6th committee subpoenas that the D.C. Circuit is just a bunch of political hacks who will make up facts and think MSNBC is equivalent to God's gospel when it comes to the truth about January 6th.
Okay, now hold on. Before we get there, I don't do this for the numbers, people, but we did just crack 10,000 live viewers here on YouTube. Thumbs up it if you don't mind, and also, it's very nice to inundate the chat with comments. But no, go hit the thumbs up and share this around, especially clip sections from the Assange so that people can know what's going on, and just also appreciate Robert and I have talked about this at length. We've now been doing these, Robert. We're nearing 100 live streams just on the Sunday nights, which is beautiful.